We thank the congressman and woman for attending. We have short briefings now from some experts in the patent field and the constitutional field. I'd like to introduce Jonathan Massey, who has clerked at the Supreme Court and for other notable justices, to address, these are 3-minute presentations each, to address some of the constitutional issues. Thank you.
Thank you. This bill would overturn over 2 centuries of American constitutional precedent. It departs from the understandings of Thomas Jefferson, James Madison, John Marshall, who was the first great Chief Justice of the Supreme Court, and it does so in a way that violates the text and the structure and the purpose of the Constitution. Article 1, Section 8, Clause 8 directs Congress to secure patent rights in the inventors of discoveries. And what this bill does is create a first-to-file system rather than a first-to-invent system. It gives the patent to the person who wins the race in the patent office rather than to the actual inventor. The constitutional language is clear, and it's also clear that at the time the Constitution was adopted, everybody understood that an inventor was someone who created something new. It wasn't someone who got to the government first and filed an application. And everyone understood that the concept of discovery meant something new. A discovery can only be made once. Once it's actually made, there is no more discovery. And that is the premise of the patent system, and that was the constitutional understanding when the patent clause was adopted in Article 1. It's also clear that the patent clause requires government to secure patent rights. And the concept of securing rights at the time the Constitution was adopted meant that the government did not create the right in the first instance. Patent rights exist at their foundation because of the hard work and ingenuity of the individual inventor. The framers, the colonists, had just gotten over the system of royal abuses under the crown. One of the great grievances of the colonists was that the king assigned patents and privileges and monopolies to whomever he favored, rather than to people who deserved them. The patent clause meant to depart from this understanding and create a system that did not vest property rights in the government, but vested property rights in the inventor's hard work. This bill turns back the clock, ironically, to the system of the English crown, where the government is ultimately the basis for bestowing patent rights. That was not the framers' system. That's not the system that this country's had for 200 years, and that's why this bill is unconstitutional.
Next we'll hear from Adam Mossoff, who's a George Mason University law professor and an intellectual property expert.
Thank you. It's my pleasure to be here today to speak out against the passage of H.R. 1249 as an unconstitutional bill that patently ignores the one word in the Constitution in Article 1, Section 8, Clause 8, inventor. All of the arguments in favor of the bill have focused on the progress portion of that clause. Promote the progress of science and useful arts. But they then ignore the limitation on that grant of power that says that Congress can only secure exclusive rights in inventors for their discoveries. And thus the text and the historical understanding of the Constitution expressly limits Congress's power to secure patents only to first inventors. And in fact, this has long been an essential part of American exceptionalism. Historically, the United States was alone in protecting patents as fundamental property rights per this unique provision in the Constitution and our equally unique patent laws. We very explicitly and knowingly broke not only with the historical tradition in England, but the continuing tradition that developed in England throughout the 19th century and in other European countries, where they adopted first-to-file systems there at that time because they viewed patents as merely regulatory entitlements, special privileges granted by the government to advance the government's economic and other policy goals. The United States rejected that explicitly throughout court opinions by Supreme Court justices like Chief Justice Marshall, as you heard, but also Justice Woodbury, Justice McLean, Justice Washington, Commentators like James Kennedy's commentaries, St. George Tucker, his text, Blackstone's commentaries, and others, repeatedly recognized the United States secured a property right in first inventors by securing to them the fruits of their intellectual labors. And this thus directly tied the protection of patents in this country to the long-standing historical protection of property rights in land and other types of tangible resources. Thus, it's very appropriate, I think, that the shift to a first-to-file system that is being proposed in 1249 is being justified by international harmonization, is being justified by our treaties with other countries, because in this sense, it represents the death of American exceptionalism. It represents the shift from the unique American perspective of securing patents as property rights to the creators of inventors, to the European perspective on patents as commercial monopolies granted by the state to whomever can file for it first. Thus, in removing the requirement that only first inventors may receive a patent, H.R. 1249 creates the exact monopoly nightmare that the founders intended the Constitution to prevent. Through the first-to-file patent system, the federal government will create commercial monopolies, those things that were rightly excoriated by Jefferson, Madison, and many other founders, as opposed to doing what this country has done for well over 200 years, which is securing to inventors their property rights and the fruits of their intellectual labors. Thank you.
Thank you, Adam. Next we'll hear from David Boundy. David is a patent attorney patent attorney and counsel to startups and venture capitalists, which is where the rubber meets the road, taking the idea and getting the funding and turning it into a viable commercial concern. David.
Getting these companies going, seeing them turn into new products that benefit people. New companies are the lifeblood of American commerce. Recent Census Bureau data shows that all new jobs for the last 30 years come from new companies. Companies over 10 years old destroy jobs as fast as they create them. All new jobs for the last 30 years come from startups. And it's these new companies that not only create the jobs, but they create like the heart defibrillator on the wall out there that saves people, and the Google, and it's new companies. Today's patent law is a large part of the framework that lets inventors and investors and other members of teams that come together to form these new companies work with each other. A weaker patent system doesn't protect the rights that all of these people have and the expectations that they have to have of each other. That's why we don't see startups in France. That's why I've had conversations with my colleagues in the UK. They tell me that the patent system in the UK, which is what this bill models itself on, doesn't work for startups. Because H.R. 1249 just removes the legal framework that all of these investors need, it's kind of the protective cocoon that lets them all work with each other and talk with each other and start new companies. There's another really amazing bit in this bill. Today's law has several provisions that require that an inventor approach the patent office and deal with the patent office without deceptive intention. Very straightforward. You go to a federal agency, it's going to give you a benefit, you should act without deceptive intention. Strikingly, the bill removes the words without deceptive intention, 4 or 5 places. Apparently someone thinks that it's okay for inventors to deal with the patent office with deceptive intention. This removal of the basic fabric of our legal structure as well as our commercial structure is very troubling to me, and I don't think 1249 is a good idea. And it's not the way the law is supposed to work, and it will have really bad effects on the way our economy works.
Finally, we have George Summerfield, who is an attorney who represents roughly 24 universities in the U.S. and Canada, Universities, as you may know, are an important source of innovation and job creation in various states. They provide a role in their spin-offs, and that does two things. It reduces the amount of money the taxpayers need to shell out to fund the university systems, and of course it creates jobs. George, would you please come up? And we'd be glad to take questions after George finishes his presentation.
So you all have heard about the constitutional aspects of first to file, and what I'm going to do is put that aside because what I have to say really has nothing to do with whether the provision is constitutional or not. Generally speaking, universities, especially research universities, are vying today for an ever-shrinking pie of research funding that's out there. Once that funding comes in the door, it leads to inventive activity among the researchers at the institution, which in turn leads to what they call invention disclosures. This is where an inventor or putative inventor comes forward and says, I think I've invented something. Then the organization within a university that's responsible for such things will take a look at these and decide which of them are actually worthy of having a patent application filed. Now, as you can appreciate, universities are not IBM, they're not Cisco, they're not Texas Instruments. They have a limited amount of resources in which they can actually use to file applications on patents. They can't file on everything. Generally speaking then, what this means is that universities have a vetting period. They actually sit down and look through all the invention disclosures they get and say we can file on 10, but we have 30. So we have to pick the 10 that are the best. That takes time. The first to file system effectively tells universities you no longer have that luxury because you have to worry about someone beating you to the patent office. That, for a university, will be the death knell of effective patent protection. They can't compete with the likes of an IBM in racing to the patent office every time someone walks in the door with an invention disclosure. They simply don't have the resources to do that. So what's the practical effect of this? Well, universities have a couple of choices. Number one, they can file on some arbitrary subset of whatever the invention disclosures are. But the selection process will now effectively be arbitrary and capricious because it has to be instantaneous. The other thing the university can do is just not file anymore because there isn't an effective way anymore to vet the invention disclosures that come in within this first to file system. So that's what will happen at the universities. What will be the result of that? Well, university filings will effectively either go down or will have less quality. That means that licensing revenues are likely to decrease as well. The universities, once a patent issues, is able to license them to industry who will then use the technology. If the patents aren't of high quality, or if there aren't as many of them, the licensing potential is decreased. The other thing that happens is that most of the spin-off companies that come from universities license in the technology that are developed at the universities, and the university gets a revenue benefit from that. Again, if the patent quality goes down or the number of filings go down, that will have a proportionate effect upon the revenue that universities can derive from what would have been the resulting spin-offs from this technology. So as you can see, at least from a university standpoint, the people I represent, this first to file provision is entirely problematic.